The average American earns about $25 an hour. The average law firm in the United States bills out at about $342 an hour. If we're to look at the economics alone, can we deliver on our ideal of justice for all in America? I'm MaryAnn Bauer, and welcome to Pro Se Nation. Joining us today on Pro Se Nation is MaryAnn Bauer, a certified matrimonial attorney based in Hunterdon County, New Jersey. In 2014, she was named Hunterdon County Professional Lawyer of the Year, and in 2012 was awarded the Safe Community of Light Social Justice Award. Ms. Bauer specializes in divorce, custody, and domestic violence issues. She is a trained collaborative law attorney as well as a mediator and arbitrator. Also joining us today is Noel Crowley, the founding and senior partner of Crowley Crowley Law Firm based in Morristown, New Jersey. He and his son specialize in defending the rights of employees at the state and federal level in a range of cases. We'll also hear from Howard Madelon, labor and employment law partner of the firm Olander Feldman, based in Summit, New Jersey, who represents management as outside general counsel and trial counsel on a wide range of risk management and human resource issues. If we were to take the pulse of the American judicial system today, how would we assess its health? MaryAnn?
I would say that the pulse is weak and the system is ailing. And unfortunately, that's for several reasons. One of the main reasons is that there's a shortage of judges. And that probably is due in part to the process becoming very political. There are two ways to have judges appointed. Our state is one in which they are appointed as opposed to running for judicial office. And sometimes when judges are appointed, then there are situations in the State House and they're not always able to successfully make it through the process to actually sit behind the bench. So you have overworked judges, and I also think that there are more people using the system.
Mr. Crowley, do you agree?
With most of what MaryAnn said, I couldn't agree more. Certainly I feel about the system the way I would if somebody asked me, does democracy work? And the answer is, it's a very flawed system. It's just the best one that anybody's ever devised. Mm-hmm. And I think the same has to be said of the legal system. But yes, its conspicuous flaw now is the congestion and the failure of our government on both on the state level and federal level to respond by designating enough people to handle the traffic. And that impacts on the justice system in so many ways. Mostly it tends to almost coerce people towards settlement. And because there comes a time when even the most stout-hearted litigants begin to despair of ever getting a ruling.
Howard, what's your take on it? Is the American legal system, does it need an IV drip? Does it need paddles? What do you think?
I wouldn't put it out of its misery just yet, MaryAnn. I would say that I agree with the comments that were made here today. I would add that I think, in addition to the fact that we don't have enough judges, and so access to the court system is more limited than it used to be, I would say that other problems have arisen in the system, including the sophistication, particularly in certain arenas, of our court system to handle complex cases. We have, for example, mass tort systems in place. We have a divorce court system, but we do not have a business court system in the state of New Jersey. We don't have an employment dispute system in the state of New Jersey. And I believe that it is incumbent upon the court system to create, when you have a need, like we do have such a pressing need, to create those systems, put those systems in place, add more judges into a business court or an employment law court, so we can get more of our cases through the system with seasoned judges who understand the specific problems that arise in employment law disputes or business law disputes. I also think that we don't have enough teeth in what we call our frivolous lawsuit mechanism in the state of New Jersey. We have on the books both a statute and a court rule that prohibits counsel and parties from filing meritless lawsuits. I do not believe in my almost 25 years of practicing law that I've ever seen a case in which a judge was poised to actually grant a frivolous lawsuit motion. I had one in federal court, which uses a very similar system to determine whether a case was meritless, and the judge hauled us in and said, I'm going to grant certain applications that Mr. Madelon has made unless you give him a formal written apology instead. Which was the only time I've ever in my career gotten a formal written apology. I would have preferred the legal fees,
Yes.
but I'll take the apology.
But in order to get there, Howard, you need to really try a case to conclusion. Don't you think we should be exploring alternate dispute methods such as arbitration or mediation or collaborative law? Don't you really think that's the answer?
I think that that will help us take some of the strain off, but I also have concerns about the current way that our mediation system is handled. I'm also a certified mediator. I was actually involved in the pilot program when it was called complementary dispute resolution. It was handled in municipal court. The problem with the system is that the system is not designed to determine and gauge whether a case is ripe for mediation. The case management system will simply spit out a notice that says this case goes to a mediator without any sense from a judge as to whether or not that case is appropriate for mediation at a particular juncture. The other problem we have is that there is no active case management, particularly in the civil and employment litigation arena, whereas if you go to federal court, every civil litigation is managed by two judges. One is basically a discovery referee, and the other is the trial judge who will handle the affairs of the trial court. So there's less pressure on the trial judge, the federal judge who's handling that. Everything else is assigned to a magistrate judge. We do not have that system in New Jersey. It's very effective in federal court for addressing and resolving discovery disputes very quickly. In our system in New Jersey, other than on the federal level, the judge will basically know that a case has a certain number of days for discovery, but they will not get involved in discovery disputes unless it's actually brought to their attention. A lot of cases cry out for far more aggressive, active case management, and I think that's a failing that could be addressed.
So they're not proactively managed. That's
Right.
what you're saying. It's a very passive process, kind of
Yes.
just, yeah.
And in fairness, there's no way for the existing system to handle that. The judges are on overload because they're handling both the discovery phase and the trial phase of every single case. I imagine that we've had that in your context in divorce court, that you have judges, there are a few number of judges in divorce court. It's not like civil judges. There are not enough of them. They have to handle everything, and they have to handle it on a certain schedule. That's impossible.
Right.
That's an impossible task.
As a matter of fact, less than 2% of all divorce cases are tried to a conclusion. So in the divorce arena, I think that various methods of alternate dispute resolution would be very successful. And it's successful because I find that when people are part of the solution, they're much more satisfied with the outcome rather than having a decision
Foisted upon them, right.
Exactly. And the cost to try a case to conclusion is exorbitant.
Prohibitively expensive for
Yes.
most litigants.
Is cost a major barrier in the legal system today?
Absolutely. I think cost is a tremendous barrier because of the fact that the system, embedded in the system, once you get past, let's say, the initial filing of the complaint stage, is a world of discovery, which means time and expense. For the unrepresented person, of course, it's coming off of their own back, so to speak, in sweat equity. However, they get a lawyer involved, and a lawyer, most likely, if it's, for example, in the employment context, if it's a management-based lawyer, then they're doing it basically billing by the hour. In some cases, plaintiff's work can be either a contingency fee, and Noel can speak to that, of course, or non-contingency, straight hourly billing, but the plaintiff usually requests some kind of a contingency fee. So now the lawyer is spending their own time, although they're recording their time in case they ever get their legal fees recovered in the case, and the hours just continue to mount. Add to that the costs that are embedded in the system. You need to take depositions. Court reporter is going to charge you X number of dollars per hour for that. Some transcripts can range $3,000 to $4,000 per transcript. Say you have 15 depositions in a case, an employment case where an unrepresented party, let's say, or a plaintiff in an employment case needs to take the deposition of senior management and needs to take a number of other employee depositions. They may be out $60,000 in court reporter costs. Where is that money going to come from? How are they going to fund their case?
What is the environment like now in the court system for the litigant who wants to self-represent, who dares to go by him or herself, to represent him or herself without an attorney? Is the judicial system more receptive to it or not, compared to maybe 20 years ago? MaryAnn, would you like to start?
Sure. In the family law area, we're seeing more self-represented litigants. However, the judges tell them right out that you are held to the same standard as an attorney. You're expected to know the rules of evidence and the court rules. So while we are seeing more self-represented individuals, I think they're also expected to have more knowledge of the system.
And yet the irony, I think, is that a pro se litigant is a judge's worst nightmare. Because although they may be held to the same standard, they're really not. The judges will bend over backwards for them because they're aware of the fact that the pro se litigant is not sitting there with a New Jersey rules of evidence in one hand and a New Jersey court rules in the other. So that means the judge is going to have to do a lot of educating the individual. You can't punish them for not necessarily knowing all the court rules. By the same token, you can't protect them from the system. So in my experience in dealing with pro se cases over the years, it is absolutely the court's worst nightmare to have an unrepresented party in front of them.
Noel, what do you think?
I think that there's no question that's true. Some judges don't even attempt to conceal their dismay at confronting a pro se litigant. And I remember in a case where I was engaged to deal with a case that had been dismissed. I think it was a motion for reconsideration, maybe, but the case had been dismissed with the client representing herself pro se, and I was asked to reverse that by motion for reconsideration, if I'm remembering it all correctly. And as soon as I said, we're not asking any concession for the fact that the client this person was not a lawyer and didn't have a representation, and I hit a tender nerve in the judge, and he shouted at me, "And it's well that you did not. We do not give any concession here at all." And obviously he was angry at this suggestion that might happen, but it seems to me just the sheer volume of pro se applications is going to force the judges to behave more respectfully, and because the public reaction isn't going to tolerate flat-out rudeness.
Well, like most things in life, there's a level of complexity. So to compare this to medicine, for example, if you have a sore throat, you can go into the pharmacy and figure out what it is that you need to assist in helping your sore throat. The same, I think, is true in the legal process, that for complex legal issues, the system isn't set up for someone to handle that situation on their own, nor if you need surgery, you can't perform surgery on yourself. So I think we can't expect people to be able to represent themselves in complex litigation in the same way that you can't cure your own serious medical ailment.
I would say that in any complex case that an unrepresented person is at an extreme disadvantage in our system. If you think about the fact that in civil litigation or employment context, there are actual court rules that require a corporation to be represented.
Right.
That telegraphs to the average person what they need to do as well. I do not believe...
And that is true. That's true in New Jersey, and I believe it's true in California. And I think that there's a lot of people that are not aware of that. Once you become an LLC or any kind of corporation, you cannot represent yourself in court without an attorney.
That's correct.
Yeah.
The corporation cannot represent itself. And I want to add to that and this is not simply a matter that is confined to the court system. Unrepresented individuals, for example, if they are handling employment negotiations, they will do a fabulous job at dealing with the business terms of the transaction, but they don't know anything about the legal framework of their rights or the pitfalls of simply signing an offer letter and not understanding what they otherwise might be giving away. That is another pitfall of the system, because you know for a fact that management will have counsel who has done this and gone through this many, many, many times. So I do believe that there are, let's say, safety nets, like MaryAnn mentioned. For example, if you're dealing with small claims. But as you go through the ranks, those safety nets completely disappear, because the system assumes that you will have sufficient means to have your corporation represented by counsel, or to represent yourself because you have sufficient means to go through the system. Yes.
It gets to, really the whole reason that I feel like that the average person really needs to know more about the law. It seems that in every aspect of our lives, everything we do is a contract. Now, this may have always been the case, but in the past it was a handshake. Maybe life was just simpler. Now you get married, you buy a house, you get a gym membership, you enter a hospital, all of it, you're entering into a contract. So as opposed to, say, 20 years ago, 40 years ago, does the average person need to know, to have some kind of legal education, or at least be better schooled in the law, so that not so that they would represent themselves, because, sometimes that can be, it can be a very complex case, but just simply to know more. Do you think that's helpful?
Absolutely, because I think our world has changed. So years ago, if you were buying a car, you were buying a car from someone that you knew down the street. So when you shook that person's hand, that was good enough. But now that's not the case. So I think it would be very helpful to educate the public. I find with my clients, I try and educate them all the time. I refer them to different resources or give them pamphlets, because I prefer to have an educated client. I think they're a better consumer.
I think they have to be. I mean, if you consider the fact that we're not even on a paper system anymore. You want to get a gym membership today, you're looking at something online with somebody basically hovering over you saying, here's the pen, do the electronic signature, and press the agree button. Agree to what? Terms of use that spill over a page that you can't possibly understand while you're sitting there in the gym. And people are doing that in a lot of different contexts today, and I think there are a lot of dangers inherent in that system. It's like as if people believe that this is a modern convenience and that the system couldn't possibly be hurting them. This is all convenience. It's a wonderful convenience system. There's so much behind the scenes going on with the companies insulating themselves from liability, protecting themselves. The average consumer has no clue what they're signing away when they do that.
I was on vacation recently and rented a car. And I'm a lawyer. I can't tell you how many forms I signed off on just with my finger, with a long line of people behind me. I didn't read them.
Right. Noel, is it helpful, do you think, when a client or a potential client comes to you and has been up on Google and Google Scholar and has some knowledge either about the cause of action or the law? Is it helpful or not?
It's huge. It's hugely helpful, and I'm often awed by the diligence, the hard work that has been invested in researching a question. It always usually betrays the fact that the person doesn't have the background to fully understand what they've narrowed in on what they suppose to be the immediate subject, and
Right.
so they don't bring to bear the same level of learning or experience that a lawyer has. But yes, it is helpful, and it allows the lawyer, in talking to that kind of person, to more effectively contribute, to provide some help.
Some say that the legal system is going through a transformation. Do you think so? And if it's not, do you think it should?
From a family law perspective, it is going through a transformation. In New Jersey, the New Jersey Family Collaborative Law Act was passed on September 10th, and that is an excellent process for resolving your disputes. It recognizes that in every legal dispute, there's an emotional component, a financial component, and a legal component. And when you collaborate and you help the parties reach their own resolution that they've crafted, you're also giving them a skill set that they take away to resolve disputes in the future. So they're not coming back for post-judgment motions when they're arguing over college expenses or things of that nature. So I see a transformation. It's slow, but I have hope.
And I do want to say that I'm actually planning to devote a whole show to collaborative law. And what I understand of it, it's almost like a philosophy that's akin to it takes a village, right? So collaborative law is really about, you're not just dealing attorney to attorney. There's a psychologist involved. There's a financial advisor of some kind
Correct.
involved.
It's a team approach.
Right.
So the financials are addressing the financial issues for a team. So if there's a business to be evaluated, the forensic accountant values the business in a very informal way and meets with everyone, so it's a fraction of the cost. The divorce coach, who is a mental health professional, is addressing trust issues and other things outside of the process, so that when you sit down at the table, people are ready to get to business and you don't have the emotional issues driving the legal issues. It's a wonderful process.
That sounds really cutting edge. I mean, really interesting, really holistic, right? So it's
Yes.
really looking at the whole dynamic, not just strictly the strict and narrow legal issue, but sort of how the whole system works, right?
Yes, it is. And it's helping the people to become part of the solution and not the problem. And you're not sitting in the halls of the courthouse for days on end until you wind up with some sort of a forced settlement that the parties, quite frankly, are unhappy with.
And Howard, is there a transformation going on? And if not, should there be?
I think part of the problem we're facing today is the complexity of the laws. Nancy Pelosi's famous oft-quoted phrase about passing a law just to find out what's in it is not far from the truth. We have some laws that are 10,000 pages or more. It's much more difficult to give precise guidance to clients when the law has not yet been interpreted or ruled upon. The law is also, because we have very dynamic laws like the Americans with Disabilities Act, where the definition of disability is changing virtually every day. It's very hard to give clients precise guidance as to what a disability is when there's new guidance coming out virtually every day as to what a disability is. And we're almost getting to the point in that particular example where the exception swallows the rule, where everything is a disability. And then how do you manage that? How does your business possibly manage that? In a way, from putting the business hat on for a moment, businesses are also in the pro se nation too. A lot of businesses would love not to use a lawyer, would love to be able to navigate the system themselves, but it's impossible because they don't have the time and they don't have the resources internally other than getting their own in-house counsel, again, but that's an added cost layer, to actually understand how the system works. So that's the transformation I see. Complexity of the laws is exceeding the ability of the system to handle the complexities. And that's a problem.
And I think the aspect of, again, and I mentioned in the previous program, a lot of people, a lot of would-be entrepreneurs or people who want to jump into their own businesses don't realize that, they, on one level, they want to protect themselves by becoming a corporation or, C Corp or LLC, but in either case, once they do that, they can't represent themselves, they can't be their own attorney in litigation, and that can cost, a small business a small fortune. I mean, it could really put them out of business, depending on what the issue is, right? So it's almost as if, the law really needs to keep up with life. Life is changing. And Noel, do you think there's a transformation going on?
Certainly in the volume of pro se litigation, yes. And I'm supposing that will dictate its own adjustment. The system is going to have to move to accommodate, and I don't just have any real idea about what form that will take. I would hope it would be to what I alluded to earlier, that is some kind of arrangement that would allow lawyers not to have to be afraid of being held accountable for a poor result, when in fact they addressed only a small segment of the case on an isolated occasion. I think that if that were remedied, that would result in a considerable number of changes.
Well, actually, the time has gone so fast; it's amazing. And I'm going to pull a kind of Jon Stewart here. And can you stay after to do the web version? I want to thank you so much for joining me, for joining Pro Se Nation for its inaugural program. And for those of you who would like to learn more about Pro Se Nation, please join us on the web at prosenation.org. If you would like to appear on the show as a guest or perhaps contribute a feature article or blog, please send an email to info@prosenation.org. And this segment of Pro Se Nation is now adjourned. Thank you very much.
Thank you, Mary Lynn. Best wishes with your show.
Thanks.
Yes,
Thank
indeed.
you, and happy birthday to you.
Oh, thank you. Thanks.